All right, I think I should be live right now. Everybody should be able to hear me. Can you hear me on YouTube? We'll go ahead and shoot this up. I don't see my picture uh in the inset, so let's hope that it's actually showing me the way that it should. So, as always, as I begin everything, I'm not an attorney. I don't have a license to practice law. I do not practice law. What I've done is study law, tell people what I've learned and how I gather the information. I don't give information as advice to apply to a specific case. But it's general information. There we go. But it's general information regarding the law and lawful principles. So let me start from the top. I'm not an attorney. I don't have a license to practice law. I do not practice law. What I've done is study the law and tell people what I learned and how I gather the information. I don't give information as advice to apply to a specific case, but it's general information regarding the law and lawful principles, which, by the way, belong to the people. The information I provide is based upon my experiences. I've had several instances where I had to self-represent from beginning to end, and I show these things not just in YouTube. If you go to my Zoom, I'm a Zoom, my Dropbox, you can see the documents from the proceedings and what have you. And if anybody wants to see it, always feel free to reach out to me so that I can either help you navigate through Hover to find the document, or to just send it to you if you want to see it. Like, again, I would say just be careful. And as always, I highly recommend people hire a licensed attorney from their state, because I don't, and again, I say that because I don't want anything I say to be construed to be legal advice. If you need legal advice, again, seek adequate legal representation. But also, I want to make sure I make it clear that I say nothing disparaging about attorneys, generally speaking. Now, I may say something disparaging about attorneys in this episode because of the nature of what we're here to discuss. And for those of you who are a part of my email list for the Zoom, you'll be able to come in live. And I know Sawyer Stash, if you send me an email, I can help you come on and you can actually be a part of the Zoom. Sawyer Stash, can you hear me? If you hit the yes inside the chat room, hopefully that'll let us know that you can hear. Um, J Dub, can you hear me?
Yes, sir.
Okay, I appreciate it. And if you can do me a favor, also, you all check your. I don't know if you can hear me on the YouTube, because I want to make sure that everybody can hear me on YouTube. As okay, so Sawyer says they can hear me on YouTube, because I want to make sure that I'm clear with what I got going on. Um, there were this situation with me, and a lot of people probably misrepresent or misinterpret what's actually going on with my so-called other kind of cases, like the child support stuff, which I don't want to get into too much today. But without realizing that the underlying issue with all the things that go on with me now is it stems from this issue that I'm going to talk about today, which is holding public officials accountable, and then in particular, Greg Holder, who I was a former judge in Florida's 13th Judicial Circuit, and this guy set up a case management conference to try to entrap me. What Some background to what was going on is back in 2017, uh, I actually before is I acquired some properties, and I actually have Miss Bennell in. And if you can hear us, Miss Bennell, I appreciate you stopping by. And if possible, although this is not the kind of episode that typically talks about child support, can you tell everybody what you actually can help guys understand as far as insurance and how these things are going to change? Rick was on earlier today to discuss something else that you do as well, which is taxes and how they should prepare themselves to deal with their tax situation, the prepayment credits they can get for child support, and some of the other things, the other services that you provide. But thanks for stopping by.
No problem. The only thing I can tell guys is to know their numbers, know what they're paying, and also know the child support manual for the state that they're in, so that way they can maximize everything they're entitled to. Um, they can use their FSA account or flexible spending account is a way that they can actually maximize their monies because that's pre-tax monies that can be payroll deducted that they can use for things like daycare, medical insurance, services, co-pays, and stuff like that. So they just have to know their numbers.
Okay. And that would also, and some this stuff applies also to because I know this is the first of the year for people who pay taxes. Is there any additional information you would add that they should probably think about, especially because this stuff, and I know I'm gonna bring you and Rick on to discuss the changes in the insurance situation for people.
Well, the thing about it is if you're going through your employer, um, it's not you don't they we don't get the credits when it's an employer coverage, but it's going to affect us because there're going to be more people without insurance, so it'll make costs go up. But people who are self-employed may want to reevaluate things like getting an employer policy, which is just typically three individuals, and maybe adding the kid and doing uh some collective bargaining with vendors and people that they work closely with, so that way they can offer coverage. Like if a lot of these, you know how I feel about these churches, as many people that attend churches and all of this crap, they have a church has the ability to be an insurance company to do a group policy and cover their congregation if they really gave a shit about them. Sorry, but my bad. But you know how I feel. But if they really cared about their congregation, based on the size of a typical congregation, they could do a group plan and try to offset instead of begging for Bentley money, instead of begging for jet money, instead of begging for building funds, instead of begging for pastor wanting to do what pastor wants to do, like build a new wing on the house and all that. They could use that money and they could pool it and they could, be a little bit more self-sustaining. So when certain things happen, they can buffer their congregation.
Right. Understood. Makes a lot more sense. I want to get into this as I'm giving people a couple more minutes to kind of come on board. Those people, for those who don't know, you can go on my web on this my YouTube channel and find several videos that where I'm actually inside of courtrooms and taking care of courtroom kind of proceedings. And you can see me in front of city council where I'll be tomorrow to hammer on this issue with myself and Gregory Holder. Back in 2016 or so, I acquired four properties that were auctioned off by the clerk of courts in Hillsborough County during a public auction. David Acevedo was the high bidder, and these auctions, again, I said, were public. And this is part of what the clerk does in her regular course of business. He was a high bidder. The clerk issued certificates of sale and certificate of titles for each one of the properties, making David the owner of the properties. After some time, David decided that he wanted to. He sold the properties to me via quick claim deed. These things were registered not only with the clerk of courts but also with the uh, property appraiser. As time went along, some of the shenanigans uh, that were going on in Hillsborough County became more evident to me because it wasn't. I thought it was just a simple issue of a HOA foreclosed on properties that also had mortgages. The HOA um, beat the banks to the courts, and because of a law that Rick Scott passed, I believe, well, he signed into law. The legislature passed the law. Rick Scott made it law. He's the governor. Um, it allowed HOAs to do this, so nothing was illegal. Dave got the property sold to me. I began to start fighting for the properties, and the moment I started fighting for the properties, things went crazy. What? I discovered with the help of Ms. Bonnell and a couple other people is that some of the documentation and paperwork that should have accompanied the mortgages that belonged to the bank either weren't there or the banks had already had their um the loans or whatever satisfied during the bubble, the housing bubble issue. So lo and behold, I'm fighting for properties, and get in front of, and actually never actually got in front of Greg Holder. I was in front of a Judge Kaiser, who also was one of the judges during the criminal proceeding. I'll do the criminal proceeding probably next week or tomorrow um, with Daniel's, I think it's 773 TV. We're going to go into a little bit more of the depth of things. But what I wanted to do today is talk about this case management conference. And there's somebody on here also who's going to probably break their arm patting themselves on the back because they knew that this lady was never an attorney from the bank. And I'm not really sure that Mrs. Sabato was as well, but I think she did work for one of these um, law offices that are showing up on the document that I'm getting ready to share with you. Ms. Bonnell, you want to tell them what you saw when you went there and witnessed Sabato was what's her name? Mrs. I can't think the lady's name. Mrs.
Cankle,
Cone, yeah, Mrs. Cone, Roberta Cone. How you knew she was not actually an attorney for the bank?
because that wasn't a hearing. That wasn't a hearing. That wasn't anything judicial. That was a judge basically trying to check you and tell you that if you don't chill out, he gonna lock your black ass up. That's what I witnessed. That wasn't, there was nothing judicial taking place. His demeanor, him looking to her for approval, of the unethical conduct that I witnessed, because I don't know, I don't know, I would expect a little bit more integrity from a judge, because they have oaths and stuff. And that's not what I saw.
So on the screen, you all see the order that set this case management conference, and it stated here, and you said before, the Honorable Judge Greg Holder. Now, some background on this is before this case management came up, I saw Judge Holder in in another hearing in front of Judge Barbas at um, in another courtroom regarding another one of the properties I had acquired. I acquired the four properties. One was at Spinnaker, one was at Tuscany, one was at Clareside, and one was at on Bramfield and Panther Trace in Hillsborough County, which is the a suburb of Tampa, Florida. But as you see, any party claiming the interest must be present for this matter. Now, the interesting thing about this date was after uh, the Second District Court of Appeals had stayed the proceeding, and you're going to hear him talk about that. But what I recently discovered, not just looking at this, you'll see who the so-called plaintiff is, and Mrs. Andrea whoever these attorneys were. And this is out of Georgia. That might be for Aldridge Pike. But these people did not have permission to proceed properly. The interesting thing is after that, so at the case management conference, this is who shows up saying that they are attorneys for the bank. As you see, this is the right here, Debbie Satale for Banker Donaldson, Berman, Caldwell, and Burkitts. Now, the interesting part about it is under Florida law, if an original law firm or if a law firm uh, starts a case and say the lead attorney changes it, as long as the lead attorney is from the same law firm, that's fine. They don't have to get an order from the court. But if a new law firm takes over, the new law firm does have to have an order from the court that allows the new law firm to proceed. Uh, I can show you that didn't happen in this case. This lady here, Roberta Cohn, who claims that she's supposedly here for the bank, and you'll see them as they make their appearance. You see that? Clear as day, her name. But we go back here, she's not here. And someone say, what difference does that make? It makes a big difference. Oh, I think I just got rid of, there we go. And what happened to my transcripts? I just lost my transcripts. I'll pull them back up. But the reason it makes a bit a difference is there's procedures under Florida law, there's procedures under whatever law it is in your state as well. And when they don't follow the law, and let me try to pull this thing back up because I end up losing it. Problems can occur. So I'm gonna come back to this case management. So hold on, I don't know what just happened on my, hold on a second. My television just went crazy. But let me see something here. Where's my case management conference stuff again? This gets frustrating. But at any rate, I'm going to show you in the case where she did not show up for the case management conference with an appearance, which was required by the courts as well. Let's see. Hold on a second. I don't understand why my TV is operating. Maybe there's something going on with my computer and my TV, and I apologize, people. Give me 1 second. All right, people, I apologize. I'm back. So at any rate, let me show this case management conference. I don't want to lose track of this. The transcripts. I hope I didn't get rid of my transcripts. So, dang, I kind of almost lost track. It's gonna be a bad clip, but Mrs. Combs, as you all saw, there we go, claimed to be the attorney from the bank. So now we got this back. So there we go. I apologize for that. She claimed to be the attorney for the bank. And Josh, you're a little bit familiar with property, right? So anyway, are you familiar with foreclosures as well?
That's not really my expertise, but I have a little knowledge on it.
So she says she's the attorney for the plaintiff, which the plaintiff in this case is the bank, Bank of New York Mellon, allegedly. What I found out is that Bank of New York Mellon is not even in the chain of title for the properties. So this is before I sat down, and also she said this other attorney, she's also for the plaintiff, and this is from Judge Holder. He says he went ahead and he checked the Second District Court of Appeal website, and again in the afternoon and repeatedly throughout the day to see if anything had been done about the appellate court as it relates to what they've been treating as a motion for review. I filed a writ of certiorari. And part of the process is if the appellate court takes the case, the trial court typically loses jurisdiction to do anything. And actually, in this case, the appellate court had stayed the proceedings uh, related to the foreclosure. But as you can see, Judge Holder says in any event, there's no definitive action, and as such, we're pretty much stayed. But he nevertheless wanted to move forward. The crazy thing is, as you see it, he's saying he felt that this is also coming from the court. He felt it might be productive to have a case management conference given the status of this case, as well as other cases in which you are an intervener. My federal lawsuit alleged that Gregory Holder's actions were non-judicial and that his non-judicial actions open him up to, and not only just non-judicial, he's totally without jurisdiction because the appeals court actually had the case. He's not protected by qualified immunity or absolute immunity like judges typically are. That's the issue that is in the Federal Court of Appeals right now. I filed a lawsuit in the Middle District, and the crazy thing about the Middle District is the judge that presided over the case in the Middle District, who wanted to dismiss it and even dismissed my action against the city of Tampa and their police department for malicious prosecution. They're saying that they're protected because Judge Holder um, is the one who supposedly initiated the action, despite the fact that there's absolutely no witness statement, no record of anything that would have shown that I committed the perjury. And in fact, as you begin to look at, as I show you, well, this right here is my bond amount when I end up turning myself in on the charge of perjury in official proceeding. As we go through the other documentation, and here's the actual official count against me, which was initiated by Gregory Holder, a sitting judge. I I don't know if anybody else has ever been familiar with a judge who became part of a criminal investigation, but you can see the one count of perjury. And by the way, this is what they're claiming that I said. Did make a false statement which he did not believe to be true, to wit, he was indigent and did not own any property under oath in an official proceeding regarding a material matter, contrary to the form of the statute, in such cases made and provided. You're going to find out later on next week, particularly when we go through the case a lot better than what we are today, that none of that ever happened. Here's a CRA. And on the witness list, my witness list are these judges who are the judges that presided over my properties at one point or the other. The person that Greg Holder called was actually the bodyguard or the head of security for the city of Tampa's mayor, which was also interesting. And then there's an updated witness list. What happened to help me out was the Florida Supreme Court stepped in and sent a visiting judge in. This is the dismissal of the perjury charge. This is the court docket sheet that dismissed the case and from the visiting judge. And you can see there's the order dismissing with prejudice. And actually, this is the signed order dismissing with prejudice by Thomas McGrady. And the thing that I wanted to make clear for everybody, especially because I want you all to pay attention to when I go inside the city council tomorrow, because the city of Tampa kind of turned a blind eye to the misconduct of their police officer. And why I want to hold Gregory Holder accountable is, for those who don't know, Gregory Holder was a judge for some 26 years in Hillsborough County, Florida. So there's no telling, Josh. There's no telling how many cases Gregory Holder or Michael Victor presided over, or Michael Victor may have initiated an action for. It's my contention that every case that Gregory Holder, this particular judge, touched should come back. The people of Florida, anybody in Hillsborough County who ever had a case in front of Judge Holder should be either asking the DOJ or the state attorney, hey, I think that if you think you may have had something awry happen in your case, or if you were ever arrested by Mike Victor, it would make sense to me that you would say, I want that case to come back for review, because it's pretty clear that Gregory Holder is not honorable. He tried to set this thing up to entrap me. And let me show y'all something to give you a little bit more background, because
Yeah, that seemed like that's out of his scope of like out of his scope. Yeah,
yeah,
acting outside of his jurisdiction.
yeah, absolutely. Judges aren't supposed to be starting initiating case actions. So let me help y'all out, just so you'll know I'm not just pulling things out of my behind. So right here, and if you don't live in Hillsborough County, Florida, that's not my fault, that's yours. So at any rate, everybody should be able to see the Google machine. In Hillsborough County, in Hillsborough County, anybody can pull up anybody's case. This is not special. Uh, we have a pretty good system here that allows us to do it. And because I also have my own account, I can just pull up anything. So let's just go to the case number was 2017 criminal felony, and then let's go to we're not going to do that. Let's go to the 2017 CA. I think it's 0071. And I'm going to show you all something. The case, no, that's not it. Let me go back and find Michael Wire. The case that was in front of Gregory Holder was only for the property that was the subject of a foreclosure. I don't know. Oh, it's 15. See, I put 17. So I want to show you something. Show you people something. As you look at the parties in the case, and you see the opposing counsel should all come up in here. Kaiser, see, Holder was here, Kaiser was here. But let's go back to the actual events docket. Let me show you something. Josh, you do know that an attorney that shows up in the case has to have a notice of appearance, right?
Yes, correct. Got to put you on notice. Notice is mandatory. That's your safeguards.
Right. These attorneys that showed up with these notices of appearances, which you're going to miss in the case that was filed, so it's about February 14th. See, I filed a motion to intervene by Florida law when they came to put the writ of possession on the property. And you'll be able to tell by looking at my writing is a lot better today than it was back here. So, but this was Florida law. Gregory Holder actually denied my motion without affording me a hearing, and I was the actual registered owner of the property. So there was never any question that I was the owner of the property. And as time began to go on, I started realizing that hey, there was some shenanigans going on that, in short, they were stealing people's property. When I started fighting, it seemed to have pissed them off, and that's where everything else started to go kind of awry. But as you see inside this the docket, this is my me trying to intervene in the case. And actually the proper way to do it is um wouldn't it have been a special appearance, it's just been a motion to intervene, which I think I did file before this, and he just was denying me. He didn't let me intervene at all. In fact, he'll show it to you. But the crazy part about it is nowhere during the case management conference do you see when from the time he first called the case management conference, see right here, to the order setting it, the the other attorney never filed an appearance, and she didn't file an appearance anywhere down here. The original bank that filed the complaint, Morris, Schneider, and Wittstadt, this bank ended up filing bankruptcy because one of their partners went to prison because he was embezzling money from his clients. And by the way, there's their so-called allonge or note. Bank of New York Mellon is not even the bank that loaned the money. But for somehow they never loaned the money, and they never showed proof that they ever had an entitlement to the property. We can find all this stuff here and kind of pull it down and get into the weeds of it a little bit more. I think there's another video that already have done that. My point for this is to show that Gregory Holder actually allowed somebody, you see Mrs. Martin in here, but not even Sabato. but Salvador could have been a part of this Bush White. As long as she worked for this particular firm, they can be interchangeable, and that there's no problem with that. But the crazy part about it is Roberta Cohn never filed a notice of appearance for the bank. Gregory Holder called that case management conference for the purpose of trying to entrap me or trying to create this narrative that I had committed perjury. The only time it was ever said that I didn't own any property or what have you was by Greg Holder. My contention was I did own the property, that they took the properties out of my name without giving me a day in court. So, in essence, somebody's actually living in my property to this day. So, again, I'll be at the Tampa City Council meeting tomorrow at 9:30. I wanted to just kind of get this in here to kind of get everybody an idea to know that Gregory Holder called a case management conference. In the case management conference, I don't even know where Mrs. Cohn came from because she wasn't listed on the notice of appearance. And let me try something here. Her name is Roberta Cohn, Florida attorney. She's actually a divorce lawyer. Kind of interesting. A divorce lawyer that showed up. Real estate issues and divorce, okay. But she didn't show up as any of this at any other time in the case. I'm definitely gonna look into this a little bit more. But I knew she wasn't a real estate attorney and she had never made an appearance for the bank any other time. So we'll get into a little bit more of that. But hey, with that being said, I'm finna get ready to get out of here. I got a couple other things to get ready for tomorrow. My presentation for one in front of Tampa City Council. Anybody has time, check it out 9:30 Thursday. And let me do some things right now to kind of show people how. Let me go to my page just for some clarity. And I know you don't want to do anything like with this stuff either, Josh, what we talked about today off air. But I think it's important for me to show people that how do I do my playlist? There we go. So do you all see my playlist on the
Yeah, I see it.
on the screen?
Yes, I know.
Okay, so what I want people to take a look at is anytime you want to see what I've done, or if anybody wants to challenge what's ever been done, here's my playlist. But right here, you can see all these are actual cases or situations where I'm actually inside of hearings, actual court hearing.
So, yeah, making it easy.
So that's me inside of a court proceeding. I don't think anybody's questioning that's me. The follow-up to this proceeding, which involved a mother who had taken me off of this, well, had waived any of the amounts owed. She That's what that case was about in a license suspension case. The reality of that case was that, well, actually all my kids are grown, but that not only did she waive that, but in the original proceeding, neither me nor the mother was there. And all of my cases are judicial. None of them are administrative. And as everybody should know, in a judicial case, procedural errors demand reversal.
That's
When
my
it comes,
same situation.
yeah, period. This case here with me and Denton, which involved the Smallwood case, out of well, actually, the case, this case is Miss Smallwood never lived in Florida. They failed to serve the um, complaint, the summons and complaint within the 120 days as required by law. They never got an extension of time to serve it,
Uh,
and the
From what the law say, that means Florida never acquired personal jurisdiction.
Florida could never have long arm jurisdiction either.
Exactly.
Right, because there's not minimal contacts. So I think as it relates to that situation, if anybody were to go look at it, the easiest thing for anybody to do, because it became a controversy without me saying any names or what have you, the easiest thing anybody could have done was looked it up. And actually, not only Holder should be held accountable, the the judges and hearing officers who don't follow the law should be held accountable as well. So here we go. I don't even think you've ever seen this before, have you, Josh?
No, I haven't seen that one.
So you see how many entries are in this damn case? I'll get to the top part later, but let's go to the bottom.
Whoa.
Yeah, I know. Supposedly transferred from Leon County. Some of the issues that unserved. So let's go. 1995, May 15, 95. Amended petition. So we don't know where the original one. Amended. And this would have to have been served by North Carolina and not Florida. And they would have had to serve within the 120 days. How they amended it doesn't even make any sense. But at any rate, North Carolina, now this could have happened had North Carolina served this guy, who was me, and got the case in North Carolina. They could have then transferred it to Florida. But what North Carolina couldn't do is just not serve me and establish the case in Florida, because this doesn't make any sense. They still would have had to serve. Never happened. So let's go back to here. Never served. Unserved, 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 unserved. So after not serving it here in 95 when it opened, where's it go? Petition service. Where's this amendment? Let me make this thing bigger. I'm getting old. So you see 1995. When did they amend the complaint? 1998. Between here and here, more than 120 days passed. What would have had to happen in here
They would
is,
have had to have a motion extension of time.
and they'd had to show good cause. If they didn't do it, you can't amend it. So the bottom line to this case is any order that came from this case is unenforceable, which is what you heard Denton say in that hearing, and everybody take the time to go watch that master class. He said it. When he in fact, when he even challenged me as to why is it that it matters 20 years later, it's still a void order. That's the
It's
bottom.
unenforceable because it's void. You can't enforce a void order.
Right. But the issue that the state of Florida or these people here in Hillsborough County have with me is the issue ain't child support. The issue is I knew that they were stealing people's houses. I have a resume. And all I asked Judge Ayers to do when she closed out the case administratively, that wasn't so much the big issue with me. This is what I filed and asked her to give me an order on. Stated the facts. You see that? It shows May 15, 95 filed the underlying action. There's no evidence in the record that Smallwood lived in Florida when the petition was filed. There's no evidence in the record that the children in question lived in Florida when the petition was filed. Neither the DR nor the attorneys have provided proof that the children or Smallwood had minimal contact with Florida. We're fully
That
transparent.
also goes to subject matter jurisdiction as well because they had no authority
Exactly.
to hear the case.
Exactly. And anybody who pulled up a case like this would know that. The original complaint fails to plead a basis of grounds that gave a Florida court grounds for establishing jurisdiction. See how we cite the cases? Failure to adequately allege the relevant jurisdictional basis. What does it do to an order?
It voids it.
Any attempt
Any
to serve.
attempt under the
Well,
service long statute.
in 1995, well-established law required the service of process of an initial complaint and summons within 120 days of filing. The 120-day limit to effect service of process established by Federal Rule of Civil Procedure 4J is to be strictly applied. And if the service of the summons and complaint is not made in time and the plaintiff fails to demonstrate good cause for the delay, the court, what's that word? Oh, my bad, Josh. The court what?
The court must dismiss the action as to the unserved defendant.
Period.
Correct. Yeah.
That ain't me. That's the law. It doesn't show a successful service or process of the initial summons and complaint on the respondent within the first 120 days of the filing. The clerk of court's docket for the case has no showing of any effort to show good cause within 120 days. We've already seen that. We in 95 the law mandated the court dismiss the action if the initial service or process was not complete within 120 days and there was no showing of good cause for the failure. There's the case. It's Hodges versus Noel. And this is a unique kind of case. And I just thought it was important to talk about holding public officials accountable. That's why I'm going to hold Judge Ayers accountable as well.
I mean, you have no other choice. It's a board order. I mean,
here you go. A trial court may not exercise its discretion to refuse to dismiss a case under Rule 1070I unless there is record evidence of efforts made at service during the 120-day service period, which would support a finding of good cause. We already looked at it. It never happened.
It's definitely not in the clerk's docket or not on your case docket.
The clerk's docket shows the DR amended the complaint twice without leave of court. The rule for amending complaint, that's 1.190. I know that anyway because I had to do it in my auto negligence cases. Allows only one amendment without leave of court. A party may amend the pleading once as a matter of course at any time before response to pleading is served. Otherwise, a party may amend the pleading. How, Josh?
Only by leave of the court or by consent of the parties.
Did that happen?
It's not evident in your. It's not no proof of that in your docket. That's absolutely missing.
Well-established law required the court to dismiss the second amended complaint and vacate the default judgment entered on the court on July 19th. This court held that an amendment without leave of court or consent is generally a nullity. No problem. The law requires compliance with statutory provisions and well-established law regarding service of process. And everybody everywhere talks about when people weren't served. So why anybody would mislead somebody as to what the facts are of this case was is crazy. I can disregard this order I can disregard a void order with impunity.
Exactly. You have that right. I mean, you suppose. I mean, that's you should. You have every right, and you should. I don't see why you wouldn't. It would be
order entered without subject matter jurisdiction is what?
It's void.
Everybody knows.
Ab initio.
Everybody knows this. So why somebody's running around, or I'm not saying it, why anybody would run around and tell people anything that was not, when they have the capacity to know better and they mislead people on purpose, this is what I'm determined to stop in 2026.
I bet I'm with you on that all the week, Greg, because there's a lot of that out here. Matter of fact, I think everybody out here doing that, pretty much.
Florida rules 1.540 and 12540, which this is just general civil. This is family practice. Allow collateral attack of a void order at any time. See, the issue isn't the law. The issue is the stewards of law not doing their job. I've challenged jurisdiction, doesn't matter. So anybody else who wants it in support of declaratory relief possesses the jurisdiction rendered. All I needed her to do is just sign the order. I don't need you. I don't need you to do anything for me. See that? Here's the proposed order, asking for relief of judgment, stating the reason. This is all I need her to do. It doesn't matter whether she does it or not. The order is still void. I just need you to go ahead and just get through the minutia. That pretty clear to you, Josh?
Yes, sir.
It'd be clear to anybody who even watched it. In 5 minutes, any issue as to what that case was about has been resolved. Anybody wants to challenge it, they're more than welcome to. The facts speak for themselves. There's the docket from the beginning. No summons, no service. until sometime in 99. But the only thing that matters is if the initial summons and complaint aren't served within 120 days. Initial can only be one time, by the way, people. And what's even crazy about this is, even if they didn't do it, the first time they saw me, they could have just voluntarily dismissed this case, done what they had to do to get the minimal contact or what have you, and then say, he's sitting right in front of us. He doesn't run. He's right there.
They could
Serve
have
him
served you right then.
with a new complaint, but it couldn't be for this case.
Right.
This case is dead. Just like
Also,
when a case is terminated, that case is dead. They could try to bring back another case, but the basis for establishing the case is gone, because once you go beyond the 4-year mark of emancipation, the court has no jurisdiction either. The procedural safeguards are there for a reason. And if
also,
anybody, go ahead.
alias summon doesn't cure that defect either.
Hell no. Hell no. But even you couldn't have an alias summons for somebody you don't have minimal contact for.
Exactly.
And if you listen to
That's
that video,
jurisdictional.
period. So, again, I'm not going to give energy to things that don't need energy, but anybody who wants the information, just come to the source. Fully transparent. You can get anything you want to get from here. There's a reason why I claim that I'm that 1 in 10,000 like Django. I'm here to hold people accountable, and you'll see that happening. Anything else you think we should cover before I get out of here?
Nah, we good, brother. I think you pretty much touched on the basic of what you wanted to talk on tonight.
No doubt, and I'll see y'all tomorrow. Hey, as always, sometimes it's not about right or wrong. More importantly, it's about clarity. You never reach resolution if you're not willing to engage in honest dialogue, even if the dialogue is with yourself. Take time to hug the person you love and love the person you hug. On behalf of Greg Doss, GD9 Attorney Pro Se Consultants, I'm Greg Doss. I'm the infamous DJ Squid. I'm saying peace. I'm saying chicken grease.